Welcome, and thanks for taking the time to join us today. I'm Charlie Imbergamo, Director of Strategic Programs for the Nonprofit Leadership Center. We have a few of our NLC teammates and board members in our session today. So on behalf of all of us, we are delighted to welcome you as we continue our mission to develop and connect nonprofit leaders in this virtual space, folks from far and wide. The pandemic has changed our way of work, our economy, and many organizations' policies and procedures related to vaccines, masks based on vaccination status, and other safety measures that are now being challenged around water coolers and conference rooms and in the courts. Today's session is intended to give you more information from the legal lens around these issues as we develop and refine our plans and communicate and engage our teams and community effectively, ensuring that we stay focused on legal compliance. Before we delve further into our work today, our team wants to acknowledge the pain and suffering of those who are impacted by ongoing struggles, as well as recent national and global events. Let's take a moment now to raise all those affected to our consciences. And now, to recognize you and the organizations and the communities you serve and represent, please find the chat box and type the name of your organization and location in the chat now. And as we see the organizations and locations pop up into the feed, we'll take the opportunity to celebrate each of you and the great work you're doing. We are joined today by Karen Busing. Karen is a partner at Ackerman LLP, Tampa, with more than 35 years of experience counseling and representing management in workplace legal matters. Karen is one of only about 200 lawyers who are board certified by the Florida Bar as specialists in labor and employment law. Her expertise includes representing employers in discrimination and harassment matters, hiring and firing, disciplinary matters, leave and accommodation matters, wage and hours, non-compete and trade secret litigation, whistleblower and retaliation claims, and all aspects of employment counseling and training. In short, she's more than qualified to be with us in this conversation. She's currently on the Ackerman Return to Work Resource Guide team. Earlier this year, she supported work in that area, assisting employers in navigating reopening during COVID, and now in this work. We are grateful that Karen accepted our offer to provide legal expertise on today's topic. Moderating our session today is my teammate and colleague, Karina Kletter, NLC's Program Associate. Karina has been a great driving force in helping us in this work to provide an accessible virtual experience for our participants. She's passionate about the work that we're doing and our commitment to continue to respond during this most uncertain time with hope for the future. She will take us through some rules of the road for our time together. Karina.
Thank you, Charlie. So I'm just going to go over a few of our logistics for today's webinar. To minimize background noise and distractions, all lines will be muted for the duration of the webinar. The session is being recorded and will be available on our website in the next few days. You may have noticed that we have live captions enabled, which is a Zoom accessibility feature. If you find them distracting, or if you would like to see them but don't see them yet, you can enable or disable them by going to the bottom of your Zoom screen and clicking on the icon that says CC Live Transcript. Once you click that, click the button that says Disable Auto Transcription or Enable Auto Transcription. We warmly welcome your questions. Please type them in the chat box as they come up for you, and we'll take 10 to 15 minutes at the end of the presentation for Karen to answer as many as we're able to get to. If you haven't found the chat box yet, go to the settings at the bottom of your Zoom screen and click on chat. And if you haven't already, please share the name of your organization in the chat box. We're so delighted to have Karen with us today and look forward to a great informative webinar. On to you, Karen.
Thank you very much. Let me do the share screen part here. And I go to the slideshow part, which is right here. This one. This one. Okay. All right. Here we go. Can everybody see my screen? Thumbs up? Yes. All right. Very good. Thank you so much, everybody, for being here today. I'm really looking forward to being with you. As you know, we are in a really dynamic environment. The rules for vaccines have really been moving in flux constantly. And so my ready advice to you at the start is to stay current and be ready to pivot at all times. I did notice as we were admitting people into the room today, there are some people from out of state. So I want to let you know that guidance and regulations governing vaccines varies by state and by day. I am going to be talking with you as of today, and we're going to be reviewing Florida and federal rules and guidance as it exists today. Keep in mind, it could change tomorrow. I cannot tell you how often I get a call saying, but I did this because you told me a couple of weeks ago to do that. But yes, it's different now. And so I want to make sure you realize that it's something you really have to stay on top of. And I know a couple of people asked ahead of time about resources. And when we get to the end today, I will direct you to some resources that will help you do that. I'm going to be reviewing how the rules today apply to private employers. There are some differences, again, from state to state and region to region based on public employers. So today I'm going to be talking about private employers. As I mentioned at the very beginning, you've got to keep up with developments and be ready to pivot on a daily basis. I also want to let you know that there are going to be separate considerations, not just for public employers, but also for unionized workforces. I'm not going to try to talk about that today. Again, if you're in a unionized workforce, you've got a little different scenario. You may have to negotiate and bargain over some of these things here. So the very first and most common question that I'm getting on a daily basis is, may an employer ask an employee about their vaccination status? The EEOC has come out with guidance that confirms that an employer absolutely may ask employees whether they have received a COVID-19 vaccine. And they can also require proof of vaccination. But the thing to keep in mind is that information is considered medical information. And so it must be maintained confidentially in a file separate from an employee's personnel file. So if you are obtaining copies of somebody's COVID-19 vaccine card, or if you are maintaining a log of who's been vaccinated and who hasn't, you need to make sure that that is maintained very confidentially in a separate file. It shouldn't be in their personnel file, and it should only be shared with those who have a need to know. So if you were in a setting where you had a lot of different people who were in a shared space, and a few weeks ago when vaccinated people didn't need to wear masks, and you wanted to monitor and make sure that unvaccinated people were wearing masks, that would be information that would need to be shared with the person who was doing the monitoring. Now we're in a different situation again, as happens. So the next question that I'm getting, again, most commonly is whether private employers can require employees to get vaccinated for COVID-19. And the answer to that, again, the EEOC has said unequivocally that federal EEO laws do not prevent an employer from requiring all employees physically entering the workplace to be vaccinated for COVID-19, subject to the reasonable accommodations provisions of the ADA, the Americans with Disabilities Act, Title VII, which covers religious accommodations, and certain other EEO considerations. And I'm going to talk with you about those. Now, in Montana, they don't allow this, but in Florida, an employer may require employees entering the workplace to be vaccinated for COVID-19, again, subject to the reasonable accommodation provisions, which we'll review a little bit more in detail. Now, a lot of people say, oh, no, that's not right, because Florida has this new law that bans vaccine passports. that does not bar a private employer from requiring employees, I have a typo in my slide, requiring employees to get vaccinated. It only bars businesses from requiring patrons or customers to provide documentation certifying that they have been vaccinated or had recovered from infection in order to gain access to or entry upon or service from the business. Okay, so once again, that does not bar private employers from requiring employees to get vaccinated. It only bars you from requiring patrons or customers to provide documentation of vaccination. Now, there are some businesses that have very cleverly gotten around this, including, for example, I read the other day that Live Nation has their concert protocol. You either have to provide your COVID-19 vaccination card, or you've got to provide a negative test result within the prior 6 hours. So there are ways around that particular provision. Keep in mind also that this statute, this new Florida statute, which was a codification of a governor's executive order back in April, and then the statute was codified this summer, does not restrict an employer from instituting other screening protocols consistent with guidance, like guidance from the CDC or OSHA to protect public health. For example, if CDC is recommending that employees wear masks, or if there is a recommendation that employees should undergo this, that, or the other, or if you want to require regular testing to make sure that you're protecting your workforce, you can absolutely do that. The law, the vaccine passport law in Florida does not bar that. Now, again, nothing I say applies to Montana, and there may be other statutes in other states that impact this as well. But in Florida, this is definitely the case. And also keep in mind that the vaccine passport ban in Florida, that statute does not apply to healthcare providers. So they are completely not governed by that statute. Now, as employers are very reluctant to, have been reluctant to implement vaccine mandates, they have been trying to encourage vaccination, but not necessarily with great success. And people have been a little bit worried because there have been challenges to vaccine mandates. And the main challenge was that they only have what is known as emergency use authorization. And so it's that, of course, is not the case anymore with respect to the Pfizer vaccine. That has now been granted full use authorization. The way that works is the emergency use authorization provision of the Federal Food, Drug, and Cosmetic Act allows patient access to unlicensed vaccines for emergency use under certain conditions. So that emergency use was granted quite a while ago. Now full use has been granted August 23rd for Pfizer, and it is in process for Moderna, and J&J has applied as well. Regardless of that, though, the fact that a vaccine has been issued under EUA status does not affect an employer's right to mandate a vaccine. That provision, and it was misconstrued, I think, by a number of employees who brought these challenges, that provision says essentially that employees to whom a vaccine under EUA is administered must be informed of the significant known and potential benefits and risks of the use and of the extent to which such benefits and risks are unknown, and of the option to accept or refuse administration of the product, and of the consequences, if any, of refusing it. By its terms, that provision applies to those who are administering the vaccine. Nowhere in it does it say that it applies to employers. And I think it's really important that opponents who challenged mandatory vaccines were very focused on this emergency use authorization and saying that, oh, I'm being a guinea pig. They're forcing me to be a guinea pig. And the first case that ruled on this issue completely rejected that argument. Now, the case is up on appeal. It was a big hospital in Texas. They instituted a mandatory vaccine policy and advised employees that if they refused to be vaccinated, they would be terminated. About 175 refused, and ultimately about 115 or 20 of them were terminated. And the court in that case said about the plaintiff, the court said, she says that she is being forced to be injected with a vaccine or be fired. This is not coercion. Houston Methodist Hospital is trying to do their business of saving lives without giving them the COVID-19 virus. It is a choice made to keep staff, patients, and their families safer. Bridges can freely choose to accept or refuse a vaccine. However, if she refuses, she will simply need to work elsewhere. If a worker refuses an assignment, a changed office, earlier start time, or other directive, he may be properly fired. Every employment includes limits on the worker's behavior in exchange for remuneration. That is all part of the bargain. So again, that is from the first ruling on one of these cases that challenged emergency use authorization of vaccines. And now that we have full use authorization, that challenge does not really even exist with respect to the Pfizer vaccine. And I suspect the others will be approved very shortly too as well. There is additional support for mandatory vaccine policies. After these challenges were filed, the Department of Justice did a detailed, lengthy memo in July, and they concluded again that that section of the Food, Drug, and Cosmetic Act that applies to emergency use authorization does not prohibit public or private entities from imposing vaccination requirements, even when the only vaccines available are those authorized under emergency use authorizations. So again, you have further support from the Department of Justice that you can impose a mandate. It is not a violation of the Food, Drug, and Cosmetic Act provision that has been challenged, or the basis for these challenges. Now, one of the things that all employers need to keep in mind is the OSHA guidance, and this predates COVID-19. Employers have a general duty to provide a safe workplace free from recognized hazards that are likely to cause death or serious harm. That's been the case all along. That is called a general duty clause. And so OSHA has been issuing guidance from the onset of the pandemic, basically saying employers should be doing everything they can to keep their workplace safe. They should encourage protocols like masking and wiping things down. And then when the vaccines are available, they should be encouraging vaccines. Well, on August 13th, they issued new guidance for non-healthcare workforces, specifically recommending that employers consider mandating vaccines or regular testing. Well, that's a pretty big deal, because if an employee suffers an illness or injury at work, you want to be sure that you can defend any claim that you were not providing a safe workplace by saying you were following OSHA guidance. OSHA guidance now recommends that employers consider mandating vaccines or regular testing. So keep that in mind. That's going to be the standard of care by which your business is judged. Are you following authoritative government guidance for maintaining a safe workplace? And there you have it. OSHA, as of August 13, recommends that employers consider mandating vaccines or regular testing. Now, healthcare work sites or workforces, that includes sites where services are provided within other sites. So if you have a healthcare work site, a clinic on site, and you're not a healthcare work site otherwise, it would apply to that clinic work site unless you fall under one of the exemptions. So OSHA issued an emergency temporary standard. That's different from just guidance. An emergency temporary standard has the force and effect of law. It is a regulation. Healthcare employers must encourage employees to get vaccinated, and they have to provide certain paid time off for vaccination and any side effects. They have to do an assessment of their workplace and a whole lot of other things. In the 916-page emergency temporary standard, there are a lot of things they have to do. So unless they're exempt from that. So keep in mind that the general guidance is not the one that applies to a healthcare work site. Then we come to the CDC guidance, and this has been kind of the big voice behind everything from the beginning. The CDC has promoted the benefits and the safety of the approved COVID-19 vaccines, and the CDC recommends that all individuals who can safely get vaccinated against COVID-19 do so. And according to the CDC, and this is all information from their website, COVID-19 vaccines currently approved or in development in the US do not contain the COVID-19 virus and will not make you sick with COVID-19. Getting the COVID-19 vaccine will not make you test positive for COVID-19. COVID-19 vaccinations have been highly effective at preventing you from getting sick with COVID-19 and may prevent you from experiencing the most severe consequences of the disease and spreading the virus to others. There have been a lot of breakthrough cases with this new Delta variant, but it is clear that the bulk of people who are suffering serious consequences as a result of that are unvaccinated. And those who have been vaccinated, it does help keep them less from getting more sick. COVID-19 vaccines do not change your DNA, and COVID-19 vaccinations are an important tool in helping to stop the pandemic. So again, if somebody develops COVID-19 and claims it is from your site, the standard is going to be, were you following authoritative guidance under OSHA, under the CDC? Are you doing what you should be doing to protect your workforce? So keep that in mind, that the CDC guidance is, again, to recommend that all individuals who can safely get vaccinated against COVID-19 do so. The CDC guidance does not apply, doesn't address employers. It doesn't tell employers what to do, but it does talk about exposure and recommendations for different kinds of work sites. So keep that in mind and consult that resource regularly. Also note CDC guidance changes on a very frequent basis, not necessarily daily, but very frequently. So you've got to keep on top of the cdc.gov site. So if you decide you want to roll out a mandatory vaccine policy, what should you do? Well, first off, you want to let employees know it is coming. There will be some portion of the workforce who will object. You may want to first conduct a confidential survey to determine the percentage of your workforce already vaccinated. That can be useful for a couple of reasons that I'll cover a little bit later on. If you decide you are going to roll out a mandatory vaccine policy, you should let people know that they may apply for reasonable accommodations based on a disability under the ADA or a sincerely held religious belief under Title VII. And you should establish a formal process for applying for and addressing requests for exemption from the vaccine. And I'm going to talk a little bit more in a minute about the standards, because they are different, where someone is claiming a right to an exemption based on a disability from when someone is claiming a right to an exemption based on a sincerely held religious belief. So let's talk first about the former. What if an employee objects on the basis of a disability? Well, if an employee needs an exemption from a vaccine requirement because of a disability, the employee must let the employer know. And for that reason, I would recommend that you have your forms ready. The employer is entitled to obtain documentation from a healthcare provider substantiating the need for exemption. So anytime an employee asks for an accommodation in their work environment, whether it's an exemption from a vaccination or any other work standard, you as the employer are entitled to obtain documentation substantiating the need for that accommodation. And there are all sorts of things you can ask for and details. I'm not going to try and get into that, but after review of the documentation that's submitted, you should then engage in what we call the interactive process. And in that process, you're simply talking with the employee about whether there is a reasonable accommodation that would enable that employee to perform the essential functions of their job without undue hardship to the employer and without endangering the safety of the employee or others. In this case, what we're talking about is you talk to the employee about in the interactive process about whether there is some accommodation that would enable that employee to do their job without being vaccinated and without endangering the safety or health of others, without undue hardship to the employer. In doing this, you are going to conduct an individualized assessment. This is not going to be an across the board. You can have an exemption for ABC. It is not across the board. The EEOC wants you to conduct an individualized assessment. So you're going to look at the documentation from the doctor and what it is that the doctor says is the reason this person cannot have a vaccine, what their particular disability is. And then you're going to look at their job duties, their work environment, whether the employee works alone or with others or works inside or outside, for example. Those are factors that might affect your decision about what accommodation would be reasonable. You're going to consider the available ventilation where they work, the frequency and duration of direct interaction with others who may or may not be vaccinated, the number of partially or fully vaccinated individuals already in your workplace. This is where I mentioned earlier, you might want to do a survey. It's really useful in conducting your individualized assessment and considering requests for exemption if you already know what percentage of your workforce is vaccinated and which people this person who is needing an exemption work with. Are they working with fully vaccinated individuals or are they working with unvaccinated individuals? Are they working with anybody who has a serious health condition, an immunocompromised individual or something like that? Because then you're risking their health. I mean, there are lots of things that go into this. Consider whether employees are wearing masks or undergoing routine screening and testing. If you're already testing people twice a week, maybe it's not as big of a problem for an exemption. The space that's available for, we used the term social distancing at the outset. Now we're talking about physical distancing and any other protective measures that you have in your workplace. Again, it is a very individualized assessment. It's not an across the board situation. You look at the individual, what their job duties are, what their medical situation is, and where they are in the workplace, their exposure to others, and the risk to others. If that individualized assessment demonstrates that an employee with a disability who is not vaccinated would pose a direct threat to himself or others, then the employer has to consider whether there is any other reasonable accommodation that would reduce or eliminate the threat without undue hardship to the employer. If the employee could do their job fully, productively, efficiently from home, that would be one accommodation. If they can't, and you cannot reduce or mitigate the threat to others, then you have to make a different decision about allowing that employee to come back into the workplace. So that's where somebody has a disability, a medical condition that warrants an exemption or that they believe warrants an exemption. So what if you have an employee who has a religious objection to vaccination? Again, the employee must notify the employer of the need for the exemption based on a sincerely held religious belief. My recommendation is that you ask the employee to provide a written statement detailing the religious principles on which the employee's vaccination objection is based, any religious tenets that prohibit the vaccination, any other pertinent information. The EEOC says that the employer should ordinarily assume that an employee's request for religious accommodation is based on a sincerely held religious belief, practice, or observance if they say it is. In other words, they don't like the employer going too far down the road of how sincere is that belief because it's really hard to tell. However, if you are aware of facts that provide an objective basis for questioning either the religious nature of the objection or the sincerity of the particular belief, you certainly may request additional supporting information from the employee, because again, they have to establish that they have a sincerely held religious belief and that it's the basis for their objection to the vaccination. Once they've provided that documentation to you, then you have to go through the interactive process again. It's the same interactive process that we talked about before. That term simply means having a discussion with the employee to explore whether there is a reasonable accommodation that the employer could make without imposing an undue hardship on the employer. Now, considerations relevant to an undue hardship in this setting can again include the proportion of employees who are already vaccinated or fully or partially, and the extent of the employee contact with non-employees whose vaccination status could be unknown or who might be ineligible for the vaccine. Again, their job duties, all of those things you consider. And then the standard for what's reasonable is very, very different when you're talking about somebody who has a religious objection. You have to work a lot harder with someone who's got a medical situation that bars them from getting a vaccine, makes it contraindicated for them. For persons who just have religious objections, employers do not have to make any accommodation that imposes more than a, quote, de minimis burden, a minimal burden on the employer. So it's a very, very different standard when someone is objecting on the basis of religion. And there, in the interactive process, there are lots of questions that you can ask and lots of details and information that you can get to determine, again, whether this is something you need to do for this individual or not. Now, there's one other category that comes up because, and it's pregnancy. So sometimes you have an employee who objects on the basis of pregnancy. There's now a lot of data out there about the safety of vaccines for pregnant women, but you still get these objections. So let me just mention briefly that there is the Pregnancy Discrimination Act, and that generally forbids discrimination based on pregnancy with respect to any aspect of employment. So the EEOC has said that employers do not have to treat pregnant employees more favorably than others who are similarly seeking to be excused from a mandatory vaccine. Okay, so pregnancy by itself is not considered a disability under the ADA. However, there are certain conditions that can be a disability. Preeclampsia, for example, somebody who has to be bedbound during pregnancy. There are conditions that can amount to a disability, but in general, just regular old pregnancy is not a disability. So the EEOC says if you have if you grant exceptions to your vaccine policy for a non-pregnant employee who is similar to the pregnant employee in his or her inability to work, then you should either grant the same exemption for the pregnant employee or have some legitimate non-discriminatory explanation for treating the pregnant employee less favorably. So in general, just consider that issue out there. And so again, if an employee objects on the basis of pregnancy, if you are requiring employees with medical conditions to provide a healthcare provider's opinion before excusing them from a vaccine requirement and making some other accommodation to protect the rest of your workforce, then you may impose the same requirement on pregnant employees who do not wish to become vaccinated. As I said, pregnancy itself is not a disability under the ADA, but there are certain pregnancy-related medical conditions that might qualify, which would entitle the employee to a reasonable accommodation. That means you got to go through that interactive process, all of that. So just keep that in mind. Pregnancy is kind of another category there. Now, if you are rolling out a mandatory vaccine policy, be sure that you train those people who will have access to the vaccination information. This is a big deal, because information about an employee's COVID-19 vaccination is confidential medical information under the ADA. So although EEO laws do not prevent employers from requiring employees to bring in documentation or other confirmation of the vaccination, this information, like all medical information, must be kept confidential and stored separately from the employee's personnel files under the ADA. So keep that in mind. Vaccination information should be stored separately and shared only with those who have a need to know. The point here is that if you've got supervisors who are going to have access to the information, you need to make sure you train them. Now, this does not mean that if employees are talking to one another about their vaccination status, that is not the employer's problem. You are not sharing their information. They are sharing it. And it is pretty common that people do share it in the workforce. It's just that the employer should not be in the position of sharing it. So if an employee comes up to you as the employer, the supervisor, the manager on site and says, well, so-and-so isn't wearing a mask, are they vaccinated? You don't have the ability to answer that question legally. So you can just say, I'll address the situation. That's it. Okay. Now, there are some different considerations that come into play when the vaccine is administered by the employer or its agent or by a third party. And when I say or its agent, so if your business has, daycare or whomever come in and send a nurse on site and administer the vaccines on site, that would be administered by the employer or its agent. As opposed to a third party, which would be, go to CVS, go to Walgreens, get your vaccine there, those kinds of things. So if it is being administered by the employer or its agent, you have to be careful about pre-vaccination screening questions because those can elicit information about a disability. You also have to be careful about limitations on vaccine incentives. So again, if a vaccine is administered by an employer, an incentive, whether it's a reward or a penalty, cannot be so substantial as to be coercive, according to the EEOC. Because vaccinations require employees to answer certain pre-vaccination disability-related screening questions, a large incentive could make employees feel pressured to disclose that information. And that limitation would not apply if the employer is offering an incentive to employees to provide their documentation that they received it from another third-party provider. That's not the employer. But if it's significant, you may want to find a way to offer it to those who cannot have the vaccine due to a disability. So for example, if someone has had a transplant, they may not be able to get the vaccine. If you're going to offer a very substantial incentive, you might want to find a way to offer it to someone who cannot get the vaccine due to a disability. Okay, may an employer offer an incentive to employees for their family members to get vaccinated? The answer to that is no. So in the very beginning, I mentioned the ADA, the Title VII, and other EEO laws. So the other one that comes into play is called GINA. It's the Genetic Information Non-Discrimination Act. That act and its implementing regulations prohibit employers from providing incentives in exchange for genetic information. So the pre-screening questions that the employer or its agent must ask before administering a vaccine would include medical questions about a family member, which could lead to the employer's receipt of genetic information in the form of family medical history of the employee, which would be a violation of GINA. Therefore, the employer is not permitted to offer incentives in exchange for a family member getting vaccinated. Again, an employer can still offer the employee's family member the opportunity to be vaccinated by the employer or its agent if they take certain steps to ensure that they're complying with GINA. So the employer would have to not require employees to have family members get vaccinated, cannot penalize employees if their families decide not to get vaccinated. They have to ensure, again, that all medical information obtained from family members during the screening process is used only for purposes of providing the vaccination, is kept confidential, and is not provided to any managers, supervisors, or anybody else who would make employment decisions for the employees. And you have to obtain prior knowing voluntary written authorization from the family member before the family member is asked any questions about his or her medical conditions. Now, the latest development, and I'm sure everybody saw, Delta Airlines is charging unvaccinated employees $200 more a month for their insurance premiums. That's the question that's been coming out. Can we do that? May an employer charge higher insurance premiums for unvaccinated employees? Probably yes, with some caveats. Premium charges are generally governed by the HIPAA regulations, the Health Insurance Portability, blah, 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 Act, applicable to wellness programs. Now, we do not yet have specific guidance from the EEOC regarding premium incentives. And so we're kind of working here by analogy to premium surcharges for smokers. Generally, we believe that the wellness programs applicable to a health contingent participatory requirement would apply. So in other words, it might be permissible to charge more, but you've got to have some out for employees for whom getting the vaccination is not medically advisable. And the total amount of the incentives and rewards combined cannot exceed or should not exceed 30% of the total cost of medical coverage. So again, this is if you're going to charge higher insurance premiums. We have a 10-year history of charging higher insurance premiums for smokers and non-smokers. And I think that by analogy, that's what people who work in this field are suspecting is going to happen, that we will have some guidance that says it is permissible, but these are the same limits that you would see on the differential coverage with respect to other employees. We do not yet have clear guidance from the government agencies authorizing this, but it seems to be that people are going to rely on the same analogy as with charging higher premiums for individuals who smoke. So just keep that in mind. We're waiting on formal guidance on that. Okay, so people are calling and saying, well, I don't know, I'm moving toward a mandatory vaccine policy. Can I put in my ad that I am going to require a vaccination? Well, we don't have direct guidance from the EEOC on this one, but presumably you may do that as long as you make clear that you will consider reasonable accommodations for those with disability or religious objections. And just for example, maybe the ad would say the company requires all employees to be vaccinated subject to federal, state, and local laws regarding reasonable accommodations for disability or religious reasons. Again, you can't do that in Montana, and there may be other states where there are limitations, but in Florida and under federal law, you could do this. It's a little trickier about asking for vaccination status in job applications versus once the person's already employed. So you sort of have to navigate this carefully. So you may ask about vaccination status in the application, but you should be careful not to ask questions that would elicit information about a disability. The EEOC has said that merely asking whether a person is vaccinated is not a question that would elicit information about a disability, because there are lots of reasons people might not get vaccinated. But if you ask it in a yes or no fashion, that's okay. And if the answer is no, you should not ask for any explanation at the job application stage. So you could say yes or no, blank, blank, that's it. And then you should definitely put, please do not provide any additional information. I would not recommend asking applicants to submit proof of vaccination at the application stage. However, it is fine to tell them that they will be expected to submit it when they start employment, absent an authorized exemption for disability or religious reasons. So again, it's sort of, you have to navigate this very carefully. May an employer ask for proof of vaccination? I mentioned in the beginning, yes. But again, I wouldn't do it at the applicant stage. You may ask if an employee will be able to submit proof of COVID-19 vaccination prior, or excuse me, if an applicant would be able to submit proof of COVID vaccination prior to the start of employment. But again, you should do so with yes or no, and tell the applicant not to provide any additional medical or other information in their response, because you don't want to do anything that would cause you to elicit information about a disability. You certainly may ask if an applicant would be seeking an accommodation on disability or religious grounds, but again, I would tell them not to provide any medical or other information in response to the question. I'm not sure I would even include it. You may condition an offer of employment on the candidate submitting proof of the vaccine or being granted a reasonable accommodation on disability or religious grounds. So the main thing to keep in mind is that you can absolutely ask for proof of vaccination so long as you are making clear that there are exemptions available, possibly available as a reasonable accommodation on disability or religious grounds. Your obligation is not to provide the exemption, but to explore whether there is a reasonable accommodation that would allow you to do so and still protect the safety of your workforce and the people you may be serving. If an employee refuses vaccination after you have rolled out a policy requiring it, may an employer mandate testing? Yes. In fact, some employers are rolling out a policy that requires either vaccination or mandatory testing twice a week. The ADA requires that any mandatory medical test of an employee be, quote, job-related and consistent with business necessity. Well, the EEOC has said very clearly that because of the COVID-19 pandemic, employers may take screening steps to determine if employees entering a workplace have COVID-19 because an individual with the virus clearly will pose a direct threat to the health of others. And so that mandatory testing would fall under one of those screening steps. So again, EEOC unequivocally has said employers may take those kind of screening steps to protect your workforce because the virus will pose a direct threat. So if you decide you're going to mandate testing, if somebody says, I'm not going to get vaccinated, but I will get tested, who pays? Well, we're still waiting on formal guidance on this. As of right now, the guidance is that the employer pays for testing. So if you are not doing it on site during working hours, then the employer should pay for the test and the employee's time and any associated expense with getting the test. Many employers are avoiding that issue by contracting with an agency to come to their work site and do the testing on site once or twice a week during regular working hours. So then the employee doesn't have to be paid anything extra. You don't have to worry about whether they're driving 10 miles and have to be compensated for that. You can just have it done there. So, but at this point in time, the current guidance is that if the employer mandates testing, we will see whether they come out with some guidance that says where an employer mandates a vaccine and the employee elects not to be vaccinated and instead elects testing, whether the employer actually has to pay for that. We will see what happens on that. Do employers have to pay for leave for employees who are exposed? It depends on whether the employer opted to extend the leave under the old Families First Coronavirus Act, Response Act, until September 30. Most employers that I'm aware of did not do that. And so if not, unless the employer is a healthcare provider who is subject to the new OSHA temporary standard, then it would depend on your PTO policy. But most employers did not, that I've worked with, did not extend the leave provisions. It was voluntary to extend that to September 30 if you wanted to. If you didn't do that, then it depends on what, and you're not a healthcare provider subject to the OSHA emergency temporary standard, then it would depend entirely on your PTO policy. So best practices, again, follow OSHA and CDC guidance as it changes. If you have tricky issues here, contact your employment law counsel and get some help navigating them, especially when it comes to the accommodation issues, because they can be very tricky. Okay, we had a couple of questions that were presented ahead of time. And one of them was, where can I go to find good resources on this? And my recommendation is that your first stop be the EEOC Technical Assistance Guidance on COVID-19. All you have to do is enter into your search engine, EEOC Technical Assistance COVID-19, and you will get the EEOC press release. It will pop up immediately. And in the very first paragraph, it says EEOC's issued technical assistance, and there's the link, technical assistance. And it has everything you need, and they keep updating it and adding to it. So all the information about vaccines is in section K of that technical assistance. The other things that you should really keep up with in terms of resources, you should definitely keep up with the CDC site, cdc.gov. There's changing guidance on protocols. There's changing guidance with respect to particular industries and what you should do. And the third place you should look is OSHA.gov. OSHA has been coming out with guidance from the beginning of the pandemic. One of the very first things that OSHA said is that every employer should create a COVID-19 plan. Now, that's a fancy word for saying take a look at your workforce, see what your exposure is by employee, and take steps to minimize that exposure. Doesn't have to be anything big and fancy. Again, unless you're subject to the OSHA ETS emergency temporary standard, then you've got to have a formal plan unless you fall under one of the exemptions. So I think that is, yep. Okay, I am not going to make these slides available to people because as I've said repeatedly in this presentation, it keeps changing. The rules keep changing. And I don't want anyone to say, oh, well, I relied on this. Well, this was as of when the date of the presentation. And I didn't check this morning. Maybe it even changed this morning, but the guidance continues to change. For a while, vaccinated people didn't need to wear masks. Now they need to wear masks. There are all kinds of things going on a regular basis, and the guidance keeps changing. So I'm not going to provide that. I am providing my contact information. If you have need further information, you are welcome to contact me. Okay, Karina, I think you were keeping track for me of the questions, right?
Yes, I sure was. And we have had several come in. If you have any more, everybody, please add those to the chat box and we'll try to get to them. But I do have 5 or 6 here to get through so far. So the first one we have is from Amy. Can you speak to how this rollout would be different to move to a disincentive policy versus a mandatory vaccine policy, disincentives such as requiring regular COVID tests, et cetera?
Okay, so if I understand the question correctly, as I mentioned, some employers are doing what we call a soft mandatory vaccine policy, which is we're going to mandate either that you provide proof of vaccination by X date, certain proof of being fully vaccinated, and then define fully vaccinated, or that you undergo regular COVID testing. And you must provide your election form to whoever is wearing your human resources hat. And that person's been trained to keep the information confidential. You must provide your election form by X date. You must provide your proof of vaccination by X date, or you have to submit to regular COVID testing. And so if somebody chooses, if you're going to make it a soft mandatory vaccine, meaning it's not really a mandatory vaccine policy, it's really, you can choose to be vaccinated or you can choose to undergo regular testing. And if you're going to do that, just have people fill out the form that they are choosing to undergo regular testing. Again, as the employer, you have the right to say no. In our particular work setting, we're not just working in a room with each other with barriers or in individual offices. We are meeting with people face to face. We are serving kids. We are serving families. We don't know their vaccination status. That might be too dangerous to do that. You might want to require vaccination and then go through the reasonable accommodation process for anybody who says they can't be vaccinated. And if you can find a way to mitigate the risk, then you can do so. And if you can't, then you have a much harder decision in front of you. So I hope that answers the question. A policy should be rolled out in writing. It should make clear whether it's a mandatory vaccine policy subject to reasonable accommodations, exemptions for those who need that as a reasonable accommodation, to the extent that you can. Provide such an exemption as a reasonable accommodation. Again, your job under the ADA and Title VII is to explore whether there is a reasonable accommodation that would enable the employee to perform the essential functions of their job. If they are asking for an exemption and their job involves interfacing day to day with families that might not be vaccinated or other kinds of face-to-face interaction where you'd be worried about that might not be an accommodation you could make.
Okay, thank you, Karen. Amy, if we didn't answer that question fully, let us know in the chat. The next question comes from Maribel asking, is this only for private organizations or for nonprofits as well?
Oh, nonprofits are private employers, yeah. Unless you're a public entity, this would apply to you. Yeah, the nonprofits are covered by the same thing.
Okay, thank you. The next question from Aaron is, can an employer require vaccinations for certain positions, but not all positions at an organization? Okay, so that's a really interesting question. The analysis would require you to determine whether the workers who are being required to be vaccinated are somehow segregated so that they're not exposed to, the unvaccinated workers are not exposed to vaccinated workers and vice versa. Do they work in separate settings? Do they have the same exposure to other people? It's a very detailed kind of job by job analysis. If you want to make some workers require subject to vaccination and some workers not, I can think of one situation where you could do that. If you have a set of your workforce, a subset of your workforce that works from home already, they're remote workers, you could have, those people don't have to be vaccinated. But if you're talking about within a single workplace setting, again, the idea is the vaccination is needed to keep the workplace safe and to avoid endangering the safety of other workers and the families and people that you serve, visitors, what have you.
And so the question would be, how are you going to do that? But if you have part of your workforce that works remotely and is never involved in face-to-face contact, then yeah, you don't have to. You could have a mandatory vaccine policy for people who are coming into your work site and not have one for people who don't come into your work site.
Okay, thank you, Karen. We've got a few more. So the next one is from Kirsten. Does the testing coverage, and I think this refers to when the employer pays for the testing, does the testing coverage include both COVID tests and antibody tests?
Okay, so from an employment perspective, I would not recommend anybody be relying on antibody tests. The EEOC has sort of objected to those, but it's not going to give you the information you need to keep your workforce safe. You need to be using COVID testing. There are two kinds: one that gives you results in 15 minutes, and one that gives you results in a day or so. You want to use some of the 15-minute ones, because if people are coming right into work with COVID testing, you want to make sure you're having good results. So I wouldn't recommend using the antibody testing, period.
Okay, thank you, Karen. This question comes from Faye, wondering how this works with a director or other staff in the board. Our nonprofit board members are not paid and therefore not employees, but what are the rights of the director on things like meeting in person or not? Can the director refuse to meet in person given the unknown status of board members and vaccination or testing?
So the guidance all applies to employers and not to people who are not under your control as an employer. So if you have board members who refuse to be vaccinated, my recommendation would be that you not have them meet in person with other people, because they are risking themselves, and particularly if you're having them come to your site to meet, that is imposing a risk on your workforce and anybody else in the workplace. If you have the right to institute whatever protocols you want with respect to people who are visitors to your work site. But again, under Florida's vaccine passport law, you can't require visitors, patrons, or customers to provide evidence of their vaccine status. I don't know how that would apply to someone who's in that role. They're not really a patron and they're not really a customer, but my recommendation would be that if you're having board meetings on site in your workplace where everybody else is vaccinated and the board members, you don't know their vaccination status, I would invite non-vaccinated people to participate by Zoom, because you want to have protocols in place to protect your workforce.
All right, thank you, Karen. We've got just two questions left. The first one is from Amy. If we adopt a policy for employees, can that be applied to volunteers, including college student placements, board members, and other volunteers?
Okay, so if someone is volunteering at your work site, again, the EEOC guidance does not specifically address this, but I would say you could impose a requirement on volunteers. Again, what I'm looking at or considering as I sit here is the vaccine passport law, which says you cannot require evidence of vaccination of customers or patrons. People who are volunteering are neither customers nor patrons. So it seems to me that you could institute a mandatory vaccination policy that anyone who is on your site as a volunteer has to comply with that. Might work for directors too. I don't know. I haven't seen that question come up.
Okay, thank you. And the last question from Kristen, can you require new hires to be vaccinated but not require current staff?
Well, that's a little tricky. If you are moving toward a mandatory vaccine program, then I would say the answer to that is yes. But if you're not going to require your current workforce to be vaccinated, I'm not sure how you would justify and say that it's a threat to the rest of your workforce for the new people only to be vaccinated. I'm struggling with that one. If you're moving toward a mandatory vaccine policy and that's going to be the goal, you can, as far as I'm concerned, you could do that. You could say, look, we're moving toward a mandatory vaccine policy, so we're not hiring new people who aren't vaccinated.
Wonderful. Thank you so much, Karen. So that was our last question. Thank you so much, Karen, for this incredibly informative and timely presentation. Thank you to everyone that participated today. We'll be sharing the recording within the next week. Please reach out to us if you have any questions and keep your eyes out for our upcoming webinars. Have a great afternoon, everybody.
Thanks so much to everybody for coming, and thank you for giving me the opportunity. Bye-bye.